I welcome you all to lesson number 5. In lesson number 4, we spoke about relevancy, and now in lesson number 5, we will speak about admissibility. Relevancy, as you might recollect, deals with the question what. What is it that is to be given to the court? What is the kind of evidence that can be given to the court? When we talk of admissibility, it deals with the manner in which that has to be given. So it is how rather than what. And of course, appreciation is the stage that follows. And here the reliability of the evidence is seen, on the basis of which inferences are drawn and then the judgment is made. We will now study admissibility in a little detail. As we know, it addresses the question how. And we look at this question once the question what has already been answered, which we saw in our previous lesson, which means that if it has been satisfactorily answered, the fact was material. In other words, the fact was relevant. Now, the fact is relevant. Does that mean that you can go ahead and present the evidence? Or is there something more about the manner in which it should be presented? I'll show you a few examples. Now, these are examples that I've taken from the Indian Evidence Act, from here and there. I'll just put these as questions to you. Let us say this is a fact which is relevant. Let us say it was in a document. Do you need to give that document in original, or could you perhaps just give a photocopy? It's a question relating to the form in which it has to be given. Alright, now there are material facts on both sides. Who is the person who starts? Who comes first? These are also important questions, right? The order in which things happen. Also, sometimes it may be in the better interests of holistic justice not to disclose something. You see, sometimes disclosure, of course, transparency is good, but sometimes disclosure can also cause some problems. Let me give you a very simple example from our childhood. You see, you ask your parents a certain question and they believe that it's better for that not to be answered. Similarly, there are some movies which are censored, which means that it is believed that too much disclosure could actually cause problems. So sometimes a fact might be material, it might be relevant, but perhaps disclosure may not be good. So these are also some rules beyond relevancy that we need to see. Likewise, you might be stating a certain relevant fact, a very material fact, but can you use any kind of language? Can you be impolite? Can you be indecent? Can you be scandalous? This is also a very important question. So as you realize, beyond the simple test, the twin test that we saw in the previous video of the fact having to be disputed plus relevant, this is what we saw in the previous video, that evidence must necessarily relate to a disputed and relevant fact. What we learn now is that it also has to follow the test of how. So there are some additional rules that have to be complied with, in addition to the rules of relevancy. Let me talk a bit now about the relationship between relevancy and admissibility. Different people talk of it differently, but you can think of it like this, that relevancy basically deals with the relevancy of facts. So when you're talking about relevant evidence, for example, you're basically talking about the relevancy of the fact. Is the fact something that is connected, right? Or is the fact very remote? So relevancy is dealing with facts, whereas admissibility deals with some other rules, some other rules which embody some other principles of whether a certain piece of evidence should be excluded or not. As far as their relationship is concerned, let us understand this in the form of a chronology. You see, admissibility presupposes relevancy, but not vice versa. In other words, the question how is addressed after the question what has been addressed. So let us say we have evidence, okay, and as you know, the evidence carries a certain fact. That's what the evidence is. An evidence is basically a medium on which you get the fact before the court. So let us say you want to say that A stabbed B. Now the witness is evidence. What is he bringing with him? A fact. So we first check, what is he saying? is it relevant? If it is relevant, then we go to the next test and then we see how should he present it. Okay, which means that we first see what it is. Is it relevant? If it is relevant, we go ahead to the next stage. In case we find out that it is not relevant, then we don't get into the question of how. You see, the stage of how is after the stage of what, and therefore it's important for you to understand this, that let us say if at any point we are looking into the question of how something must be presented, it obviously means that we have already addressed the question what, which means that we look at the rules of admissibility only after we have seen the rules relating to relevancy. Suppose something is found to be admissible in terms of the manner in which it was produced. In other words, let's think of it like this. Suppose there was a piece of evidence, okay, that is admissible. Let us say we say that a certain piece of evidence is admissible. It means obviously that the fact in it was also relevant, right? It implies that it was relevant. But it is possible that something is relevant, right? Like we saw in the previous a little while ago, that something could be relevant, but it may not have been presented properly, which means that the evidence, maybe it was scandalous, maybe it was indecent, maybe it was not presented in the right manner. It is relevant, but it was not admissible. So relevancy does not imply necessarily admissibility. However, admissibility implies relevancy. I hope you've got the idea. For something to be admissible, the fact in it has to be relevant. But simply the fact that the fact is relevant does not mean that it would be admissible. Take a moment to think about it in case you haven't. It's a simple concept. If you spend a little time on it, you'll have it. So to understand this scheme, you can think of it like this. We have a certain piece of evidence, okay? We subject it to the first test, which is the test of relevancy, okay? Now that may turn out to be either relevant or it may turn out to be irrelevant. If it turns out to be irrelevant, the matter stops right there. But if it turns out to be relevant, then you look at the second stage. The second stage is that of admissibility. All right. Suppose it passes even this, then it is now considered for the third stage, which is that of appreciation. Okay. Suppose it fails here, then again it is not considered. So understand that admissibility presupposes relevancy, because if something is admissible, it surely means that it was also relevant. However, relevancy does not imply admissibility, because as you see, it's relevant here, but it may turn out to be inadmissible finally. Pause the video and take a moment to read what you see on your screen. Essentially, relevancy, as we've discussed, is a matter of a logical connection between two things. On the other hand, the rules relating to admissibility are based on certain principles of exclusion. There are certain exclusionary rules that prevent some pieces of evidence, although relevant, from being tabled before the judge. Just take a moment and read this before you proceed any further. You can pause the video if you like. We will talk about appreciation in greater detail in the next video, but I wanted to introduce a concept to you right now. You see, appreciation is basically the test of the reliability of evidence, which is done after ensuring that the evidence is admissible, which means that you have already subjected it to a two-stage filter. The first stage, relevancy. Second stage, you're seeing, are there any other exclusionary rules of admissibility? Good. So if it's passed the first test, if it's passed the second test, now it comes to the third stage, and the third stage is that of appreciation. Okay, and appreciation, of course, is something which is done by the judge. All right. Let's look at something more. I will rephrase this concept for you now. You see, if something is inadmissible, what that basically means is that it will not reach the judge. That's what we mean. It will not reach the judge for appreciation. What that means is that if something is inadmissible, the judge does not apply his mind to it. Alright? We've understood this concept. Take a moment to think if there is any absurdity in this. You might like to pause the video at this point. My question to you is that do you find anything absurd about what I just said? I said that if a piece of evidence is found to be inadmissible, okay, it means that it will not be considered by the court for appreciation. If something is inadmissible, it will not be appreciated. Do you find something a little odd in this? Let me explain. Let me explain this problem a little bit more. You see, the rules of admissibility contain some exclusionary rules, which means that you will exclude some pieces of evidence despite the fact that they are relevant, which means something is relevant, yes, but you will still exclude them because of some other rules of admissibility. That is essentially what is happening. And why do you do that? We exclude some pieces of evidence because we don't want the judge to appreciate those pieces of evidence. What we think is it is wrong for the judge to know some things, right? It's not right that the judge appreciated certain facts. Let us say there was a certain fact that was shared between spouses, okay? A communication that was made between spouses. Now, if communications made between spouses are brought before the court, then that affects the sanctity of marriage. It affects the piety of the relationship. And therefore, there are rules in the Evidence Act. For example, Section 122 of the Indian Evidence Act says that communications that have been made during a marriage between spouses will not be admissible in the court of law. So we know such things because we don't want the judge to hear of something that was said when two people were together as a family in a spousal relationship. But let me show you this little problem now. Who is the person who decides the admissibility? In other words, who is the person who decides whether it is relevant or not? So who answers the question what? Who is the person who decides whether it has been presented properly? The judge decides it. Which means the judge has already looked at the evidence. I hope you get the point. He looks at the evidence and then says, okay, irrelevant. He looks at the evidence and then says, oh, inadmissible. But this begs a very important question. If he sees the evidence and then realizes that the evidence is inadmissible, it is irrelevant, okay? Can he delete that from his head or does it stick in his head? Very important point. A judge is expected to delete it from his head. The rule is, and what is expected of a judge is, let us say he sees a certain fact, okay? It talks about something bad about the accused, but it is not relevant. But now he has a bad picture of the accused in his head. Can he delete it from that? Practically, is that possible? Well, it's a very important question, one of the very foundational questions of the law of evidence, but at least I hope you appreciate the gravity of this question. I wouldn't really dare to give you an answer, but I can show you a couple of things that were said by none less than Jeremy Bentham himself. So Jeremy Bentham was a great English jurist. So he was a very strong critic of these exclusionary rules, which means he did not want any of these rules that prevent material from reaching the judge. So just have a look at what he had to say. He says that if something is relevant, right, it has the ability to cast light on the truth, and to deny it is detrimental to the truth, okay? And he also acknowledges the fact that a judge cannot unhear what he's heard. He cannot delete what he's seen. So you might as well allow things to be presented. So just take a moment, pause the video, have a look at this, and perhaps you might get an idea of the issue that I'm speaking about. Nonetheless, we do have some critics of Bentham, right? And what they say is that Bentham was too obsessed with the truth, right? Like we saw earlier, the law of evidence is a law of procedure, and we do require the trial to end someday. And for that, to have some rules will help. Also, you have judges who are trained. You don't have laymen. So perhaps you can expect judges to display that kind of prudence to be able to exclude in their judgment anything that they felt was not relevant. So, well, that's how our judicial system stands. So I hope you've understood the concept of relevancy and admissibility. I will talk about some of the detailed provisions in the lessons that follow, but this was essentially the relationship between relevancy and admissibility. In the next video, I will talk about the appreciation of evidence in some detail. I hope this lesson was of use to you. Thank you so much for your patience. Good day.